Hello and welcome. Are you a vocational rehabilitation staff member that is preparing for a fair hearing? If so, these are the slides for you. What we're hoping to do is give you a sense of the overall hearing process, the role of the fair hearing officer, your role in the process, let you become at least passively familiar with the structure of a hearing so that you can prepare and be successful in your hearing. So without further ado, let's get started. So here's the table of contents. We're going to take a look at beginning the fair hearing process. What are some success tips, helpful hints around that? After the receipt of request of hearing, what to do then, what happens next. We're going to look at the fair hearing itself. We're going to look at what to expect. And then finally, we're going to round that out with a definition of some legal terms that may be helpful to you. So let's jump in and get started. So the first step is really to choose a representative. So the agency will select one person that will represent the agency's position. That person will be the only individual who will communicate with the fair hearing officer and the other party. So in other words, each party has a representative, if you will, that is going to be the point person in the process. In the cases where the agency is a party to the proceeding and the agency's representative can reach out to the Attorney General's office to request assistance, that's certainly possible. But prior to contacting the Attorney General's office, please ensure you're familiar with the case, and then you confer with supervisors. You get a real sense of sort of what the agency's position is. So now that you've established sort of who the representative is going to be and you're thinking about your case, important to remember that the Office of Appeals and Hearings or the Office of Legislation and Hearings is really there to administer the hearing process. They're there to get hearings scheduled. They're there to give technical assistance with, who should come to a hearing, from the agency, how many people should we have there, those sorts of technical questions they can help with, but they're not really there to help you to prepare your case. That's really the agency's job to do. So it's an important thing to keep in mind that the role of that particular office is really one of administration. It's not really one of assistance with preparation of a case. It's one of assistance with the technical aspects of getting things scheduled and those sorts of things. So what's the role of the fair hearing officer? Important to remember, you can't talk directly to the fair hearing officer unless the other party or the other party's representative is also present. If you did, that would be called ex parte communication, and ex parte means just leaving a part out, right? So any communication about the merits of the case has to be conducted with both parties present. There are some limited occasions where you could talk with a hearing officer about sort of scheduling aspects of a case that's not considered the material aspects of the case. But in general, the hearing officers going to want to have everybody present for those discussions as well. So for all intents and purposes, any conversations that are had between a party to the case and the hearing officer need to be had with the other party present, either on a conference call or if it's in writing, copied to both parties. Whenever you send a letter or other written communication to the hearing officer, you must copy the other party. Again, it's designed to keep the hearing process fair and to make sure that everybody's got the information they need to make their best decisions as the case moves forward. It's also very helpful and advisable to keep a separate file of all your communications with the hearing officer and the other party about your appeal. It'll help you to maintain the integrity of your own record, and that's going to be really important to you. One thing to keep in mind, you can negotiate directly with the other party at any time. So if there's an opportunity, for example, to build an agreement, to come up with perhaps a solution or an agreement, that can happen really at any time, whether the hearing's been scheduled, whether the hearing's in 2 days, an hour, 15 minutes, or whether the hearing's happening, an agreement can happen at any time. Remember also that if the other party has a lawyer and is represented, you must negotiate with that lawyer first and or get that lawyer's permission to contact the other party directly. Really important thing to remember. The other thing that we wanted to touch base on is as you're preparing to question a witness and you're thinking about, okay, what witnesses do I want to bring in? You want to prepare a list of questions for each witness that factually build your case. And remember that decisions are made on facts and not emotion. So and the only way for a fact to get in to be considered in a fair hearing officer's decision is if it's entered in the form of testimony. And you elicit that testimony with what's called direct examination or asking questions of a witness. So appropriate questions are based on facts. What do you know about my situation? What happened next? Those sorts of questions that are factual in nature. The questions that aren't as helpful are a question that may be more emotion-based or a leading question. You don't know anything about my situation, do you? Don't you think that this was a bad thing? It's a leading question. Wouldn't you say that? Again, a leading question. Rather, a factual question is, and then what happened? Do you recall the events of 7/27? Do you recall, et cetera? So factual questions are your best bet. So now you've kind of got some questions for witnesses. You've got a scheduling notice. What happens? The agency will send a scheduling notice soon after receipt of a request for fair hearing. The fair hearing notice has important information. It's got the name of the hearing officer. It's got the date of the fair hearing, the fair hearing officer's contact information. It's got sort of any kind of special instructions. It's got other relevant information to the case. The other thing that it can have occasionally is it can have some, in some cases, the administrative legal basis on which the hearing is based, which gives the hearing officer or that office the right to hold hearings. It can also have some basic information about burden of proof and who may have the burden of proof. Sometimes hearing notices have that information. Sometimes they don't. It can also contain some basic information about the hearing process. So it's important to read carefully the notices you get about hearings. So, and again, we said that at any time an agreement could happen, right? The parties can reach an agreement by talking directly and informally to each other or with the assistance of a mediator, and that can really happen at any time. Mediation is increasingly being used across the country in these types of cases. And in mediation, there's a professional mediator comes in and attempts to talk with each side to find and identify the common ground that will help move that case forward in a productive way. You don't need a mediator to come to an agreement. You're free to come to an agreement really at any time. Be sure that if you're the VR representative in that situation, that you've talked with your VR leadership about potentials for agreement. Remember, you're the representative, and if you enter into an agreement with an individual, with a customer or consumer, you're probably going to be held to that. So be sure that when you're thinking about an agreement and you're thinking there may be room to make that, be sure that you've talked with supervisors, the agency, and you have the authority to make that decision. What are motions? Well, motions are requests addressed to the fair hearing officer to take some kind of action. You could make a motion to dismiss. You can make a motion for a summary judgment. In other words, and we'll talk about those definitions in a little while. Summary judgment meaning no further hearing. This is we think you've heard enough. We're asking you to rule based on what you've heard so far. You can dismiss with prejudice and without prejudice, and we'll talk about what all those things mean. But motions are really asking the hearing officer to do something. When a person requests a hearing, they've essentially made a motion. They are the mover. They've made a motion to establish a hearing. The other party will be provided a time limitation to which to submit a response to any motion. Soon afterward, the hearing officer will respond in writing. And not every appeal needs motions. Some appeals are very complex, and they have lots of different motions associated with different evidence coming in and different evidence, being left out and those kinds of things. Other hearings are much more straightforward. So just know that a motion is any request to ask the fair hearing officer to do something. Typical motions, request to postpone a hearing, which is a continuance, a request for continuance. That's a very typical motion. Request for a summary judgment, which is a decision without a hearing or without further hearing. Sometimes summary judgment motions come in the form of all the information's been submitted in advance in some cases, and a summary judgment is requested by one side or another. Requests to dismiss are another example of motions. So again, just giving you a sense of what some of those typical motions may be. So what are kind of the last steps before a hearing? Prior to the hearing date, you want to get all the documents that you want considered by the hearing officer to the hearing officer and the other party. These are your exhibits. And remember, they have to go to both parties, or otherwise it's considered ex parte communication. Exhibits must be submitted with an index. They must be organized. They must be numbered. And you also must include a list of the witnesses that you intend to present at the hearing. This process, by the way, is called, in general, discovery. So each side sort of shows their case, their exhibits, and important that they be well organized. Again, one of the most important things that the hearing officer has to do is maintain a clear and accurate record. And so they're going to want to make sure that the information that is associated with that record is clear, organized, concise, and well presented. And the hearing, the list of witnesses, you'll have already developed, because you'll have developed sort of the witnesses that will help you to prove your case. You're going to provide that to the other party, and the other party is also going to provide you the same. You want to call your witnesses before the hearing. Make sure that they're aware of the time and the location. If you've become aware of any problems, as soon as possible, let the hearing officer know. If the hearing is postponed or canceled, you're responsible for notifying your witnesses. Remember, if they're your witnesses, they're your responsibility. So if the agency made a list of 12 witnesses and you're the agency's representative, then it's your responsibility to call and make sure that those witnesses know exactly when the hearing is, where it is, can get there, all of those kinds of things. Also important to remember that the fair hearing officer doesn't provide compensation for a witness to appear. They don't pay travel, they don't pay lost wages or any of that stuff. So it's just something that you want to make sure that the witnesses are prepared for and that they know about. And simply listing a witness on the witness list doesn't guarantee that witness's attendance. Ideally, prior to the fair hearing, you should communicate with the other side regarding witness attendance. That's the fair thing to do. So, if you have somebody on your witness list and they're not going to appear, in the spirit of a fair hearing, you should let the other party know about that. So here we are at the fair hearing itself. What do I expect? Before the fair hearing formally begins, the fair hearing officer will ask if there's anything that needs to be discussed to make the hearing go a little bit more smoothly. You should tell the hearing officer if any of your witnesses have scheduling limitations, if any of them aren't coming or have a challenge, or maybe they're running late. If you have problems with your exhibits or the other party's exhibit packet, or if for medical reasons you need to take a break at certain times, or anything that may affect the flow of a hearing. Again, the hearing officer's primary role is to maintain order, maintain the integrity of the hearing, make sure that it's fair, and make sure there's a clean, clear, and concise record. So everything you can do to help the hearing officer to do that is going to help your case ultimately at the end of the day and help the overall process succeed. So what's the format? These hearings are often termed quasi-judicial. And another way of saying that is that they're almost like a hearing in court, but they're a little less formal than that. And it follows roughly a trial format. It's recorded. The typical procedure is the fair hearing officer will welcome participants. They'll read a formal opening statement. Oftentimes that opening statement has something to do with the legislative structure that allows for the hearing. In some cases the state or federal law that establishes the ability to have the hearings. Oftentimes, the hearing officer will speak to what's called the burden of proof in this particular case, and we'll talk about what that means and why it's a certain way in a little while. And general housekeeping things to make sure that people sort of understand the scope of the hearing. The idea is to keep it fair, and the idea is to create a clean, clear, and concise record. The fair hearing officer is going to put the documents into the hearing record as exhibits. In other words, if there's piles and piles of medical records, the only way that a fact gets into a hearing is if it's admitted, and it's either admitted through exhibits, through medical records, or it's in direct testimony. And so, in order for anything to be considered in the final decision, it first has to be admitted as evidence. Both sides get the opportunity to object to the admission of that evidence. So, for every exhibit that's entered, both sides get the opportunity to examine that exhibit and either object or not to its admission. You and the other party have a chance to make an opening statement. What's an opening statement? It's simply a synopsis of what you hope to prove at the hearing that day. They're not mandatory. They're optional. You can choose to make an opening statement or not, but generally, it's just a brief summary of what you hope to prove today. And generally, the customer goes first. Customer meaning the consumer of VR services. There are exceptions to that. Let's say, for example, it's a Medicaid case, or it's a case in which the agency has made some sort of movement to bring the case forward, in which case that agency may go first, because sometimes it's a little bit easier if the agency explains why they did what they did and how they did what they did and their decision-making process. It's a little bit easier for then the customer or the consumer to understand that and then begin to put on an effective case for themselves. But in most cases, the customer goes first. The order of the proceedings. Important to remember here that when it's your turn to present your witnesses one by one, that's the testimony phase of your case. And first, you ask the questions of your own witnesses, and that's called direct examination. And they're providing facts via direct testimony. The other party has the opportunity to object legally. In order to object, though, there has to be a sound legal decision for the objection. It can't be, well, I disagree with what that person just said. Rather, there has to be a legal basis for the objection. So first, you ask the questions of your own witness. That's direct examination. Then the other party has the opportunity to ask questions of your witness. That's called cross-examination. The fair hearing officer also may ask questions, and really they mostly can ask questions at any time. And when you've presented all your witnesses, the other party will present its witnesses. So they begin their direct testimony, their direct examination, getting their witness to deliver direct testimony. You then have the opportunity to cross-examine their witnesses. Fair hearing officer, again, can ask questions. And that's part of the process. When all witnesses are finished, the fair hearing officer will ask each side if they'd like to make a closing statement. What's a closing statement? It's a summary of what you think you've proven in that case. Pretty simple. Opening statement, brief summary of what you hope to prove. Closing statement, a brief summary of what you think you've proven. A lot of people sort of pre-write their closing statement in terms of the basics. Here's what we hoped we would have proven by the end of the day. Oftentimes, it's a good idea to sort of amend your closing statement from time to time, and maybe you point to specific pieces of testimony or specific aspects of the case that reinforced what you hope to prove today. That's all part of a good closing statement. But again, opening and closing statements are optional. You don't have to make them, but you can. You'll have that opportunity. Fair hearing officer will inform the parties at the hearing when the fair hearing officer expects a decision will be issued. So in some cases, it's statutorily defined. In other words, there's a certain time frame called for. Most hearing officers like to stay well ahead of that time, but they'll let you know, I expect to have a decision for you within 30, 60, 90 days, whatever it is that they feel. And that also depends on what their docket looks like as well. Either party may submit a list of findings or facts or conclusions of law that the party would like the fair hearing officer to incorporate in his or her decision. So let's say you're a VR staff member and or VR representative, and you think that, boy, the federal guidance on informed consent really bolsters our case here, or the federal guidance on the development of the IPE and this aspect of it really bolsters our case. You can submit those guidances or that part of the Code of Federal Regulation, or even previous case law, for example, which are considered sort of findings of fact and conclusions of law in support of your decision. Both sides have that opportunity. So the fair hearing officer's role is to kind of, during the hearings, to manage the flow of evidence, to ensure that each party can participate in the process. The fair hearing officer will help parties present their case by sort of reminding you what the schedule is. In some cases, helping you to rephrase or reframe your question, ensure the information is relevant, and ensure the process is fair for all sides. In other words, the fair hearing officer has a responsibility to stop testimony that's inflammatory, or that it's irrelevant, or that it's just not particularly advancing the process of getting to the right decision. They're limited in their ability to help you present your case or rephrase your questions, but sometimes they'll help, especially if they know that you're not an attorney, you haven't been trained to do that. If you're phrasing a question in a way that's not as helpful, they may help you to do that a little bit. They're aware that the folks that are representing are not always trained as attorneys. You are expected to behave as if you're, an attorney in certain ways, in terms of being prepared, being respectful, being organized, being on time, those sorts of things. But you're not expected to have sort of the sophisticated understanding of the linguistic structure of a question, and so sometimes they can help you with those sorts of issues. But in large part, the hearing officer's role is to ensure the integrity of the fair hearing process, make sure that it's fair, and make sure there's a clean, clear, and concise record. So what about oaths? If you want to testify, the fair hearing officer will administer an oath to which you may apply most of your testimony at the hearing. You'll be questioned by the other party and the hearing officer. So when you swear to tell the truth, the whole truth, and nothing but the truth, that's an important oath, and it has serious consequences if you promise and then fail to deliver. If you're then dishonest about that, there's some consequences associated with that. There are cases in which, let's say that there's a religious objection to swearing an oath, you'll be asked to, in that case, affirm that you'll tell the truth. It stands as the same thing from a legal perspective. Again, there are adverse consequences to not being honest and not telling the truth when you affirm or swear that you'll do that. What to expect? What's expected of me as a representative? During all contacts with the fair hearing officer and the other party, you'll be treated in most ways as if you're a lawyer, right? Just referenced that a minute ago. You'll be expected to be prepared, be respectful, be honest, be cooperative, and be on time. Again, you're not expected to have the legal sophistication, but you are expected to adhere to these basic principles. The hearings can be kind of overwhelming. It's sometimes they can get a little bit emotional. They can get overwhelming from a detail perspective. The best thing you can do, the thing that's going to help your case the best and reflect the best upon you and your agency, is if you remain calm and you remain focused. That is the most important thing to do. Hearing officers also recognize that these hearings can be overwhelming for the folks involved, and they'll try to help you to do that. But to whatever extent that you can help yourself to remain calm and focused, you'll help not only your case, but you'll help the overall fair hearing process. A couple of words to the whys here. Remember that the other party and the fair hearing officer are not your enemies. In fact, their skills and expertise can be really helpful to you to maintain a professional attitude if you maintain a professional attitude and ask for their help. Remember, these folks have been through this sort of problem solving. At the end of the day, it's a problem solving process, and they've been through this before. They oftentimes maybe have found novel ways to reach agreements that you may not have experienced before. So being open to their experience and to leveraging that experience towards a solution can be really helpful. Keeping in mind everybody else at the hearing is probably just as uncomfortable as you are. These quasi-judicial hearings are sometimes stressful and overwhelming for everybody. And so knowing that everybody's in the same boat and you're all working towards developing the best possible fair decision is really important. Reading all the documents you receive from the fair hearing officer and from the other party very carefully. Asking questions if you don't understand. There's absolutely no nobility in faking it, and assuming that you know something. And oftentimes that nuance of understanding that you gain from asking that question can be the difference in how you view your own case or how you view the case of the folks across the table from you. So really important that you ask questions if you don't understand. Listen carefully to the fair hearing officer's directions. If you don't understand something, ask clarifying questions, again, like we just said. And following the guidelines and the orders carefully. If you can't meet a deadline, ask for an extension in writing. There's not too many hearing officers around that if you've been respectful, prepared, organized, on time, that wouldn't be willing to give you an extension. But you're going to need to ask for that in writing and be sure that you're copying, again, both sides when you do that. Few final thoughts. Fair hearing officers base their decision on facts, not opinions, not emotion, facts. So if you can keep the facts of the case foremost in your mind, that's how you're gonna create your best outcomes. Disputes can be kind of emotional. You can be tempted to yell or get frustrated or pound the table or accuse people of unethical or unprofessional or uncivil behavior. Try to skip all that. Fair hearing officers have the authority to delay or dismiss all or parts of a case. If they're seeing that words or behavior are out of line. So it's important that you stay calm, you stay focused. Remember that calm and that focus is going to be really your best bet towards establishing your case. Please always keep in mind that fair hearing officers don't know you, and they come to every case with an open mind. So there's no prejudice in the fair hearing officer's mind as to which party may be right or wrong. They're coming in what's called de novo, which means from new, from a legal perspective, and they're looking at the case with a fresh set of eyes. Fair hearing officers know you're unrepresented, so if you're not a lawyer, they know that, and they'll assist you as best they can without prejudicing either party. And fair hearing officers act as facilitators during the proceedings. They don't have an opinion about the case. They're just facilitating the best possible fair exchange of information. And it's always the duty of the hearing officer to maintain order. That means they can cut testimony off if they think it's irrelevant. It's also the duty of the hearing officer to maintain that clean, clear, and concise record. So to whatever extent you can help them to do that, that's going to be really helpful. So with all of that in mind, let's take a look at some definitions that may be helpful to you as you move through or you encounter the hearing process. Some of them are legal terms, and some of them are, you'll see them referenced in rules or documents. You can hear them during mediation, negotiations, or at a hearing. It's just helpful to know what some of this stuff means. Admissible, made part of an official record of the hearing that the hearing officer will consider. So The hearing officer can only pay attention to evidence that is admitted to the record. We've talked about that a couple times, right? There's only a few ways that can happen. Every party has the opportunity to examine a document and accept or object its admission into the record. That's one way things can get admitted. The only way that testimony gets admitted to the record is if the testimony is delivered in response to a question or a cross-examination question on the record in the hearing. If somebody said something outside the hearing, that doesn't count unless they say it in the hearing. And there's rules around, sort of what people can present in terms of what people said and those kinds of things. But in general, in order for something to be admissible, there's some rules around that. But an admissible article is something that comes into the record and then becomes part of the record on which the case is decided. The burden of proof. The moving party in a dispute has the burden of proof, which means it's that party's responsibility to prove what it said in the hearing request is true. So if you request the hearing and do not meet your burden of proof, you will not win your case. In general, it is the customer or the consumer that moves, that appeals, that moves to have a case brought forward. And so in general, it is oftentimes the customer or the consumer that bears the burden of proof in a case. There are times when that changes. There are times when there's and you may not be involved in directly at VR in a case like this, but there are times, for example, when there's a Medicaid fair hearing, for example, and the agency has chosen to has done a continuing disability review and has chosen to discontinue services. Well, in that case, the agency has made a movement that has terminated services, and in that case, they have the burden of proof to show that enough medical improvement has occurred and they no longer meet the disability criteria and those kinds of things. So in that case, the burden of proof shifts to the respondent, to the agency. In most cases, it lies with the customer, consumer, or what we often call the petitioner. So again, just something to keep in mind. But in most cases, in a VR fair hearing, the burden of proof lies with the petitioner or the consumer or the customer. Caucus. A caucus is often a part of mediation. A caucus happens when a mediator meets with one of the parties separately and apart from each other. And what they're looking for in that case is that in that caucus is sort of to find the common ground, maybe, and the mediator may return and caucus with the other party to try to see if there's common ground for forming an agreement or the basis for the start of negotiations or the continuance of negotiations. Closing statement, simple. It's a summary of what you think you've proven in that hearing. Discovery. The process in which parties request and exchange information. Remember, we talked about it way back when each party sends the documents that they're going to submit, the witness list, those kinds of things, interrogatories, requests for documents, depositions, all different tools of what's called the discovery process. In other words, you're discovering the other person's case, and they're discovering your case, your witnesses, your documents they're going to submit, that kind of thing. Dismiss. A fair hearing officer closes the hearing file. No further action will be taken on the hearing request. Different kinds of dismissals. There's dismiss with prejudice. That means the case is closed. The fair hearing officer cannot consider the issue set out in the hearing request ever again. That's where the with prejudice comes in, right? So that hearing issue can never be brought up again. That's a dismissal with prejudice. Dismissal without prejudice, the case is closed, but the fair hearing officer may consider the issue set out in the hearing request if an entirely new hearing request is filed. So again, different situations where that's used, but just so you know what that means. Evidence is the documents and testimony that the fair hearing officer will consider when making the decision. Pretty simple. Examination is formal questioning. Direct examination occurs when you ask questions of the witnesses you brought. Cross-examination occurs when you question one of the witnesses brought by the other party, and vice versa. Exclude, to keep a document or a part of a witness's testimony out of the hearing record. Things can be excluded for lots and lots of reasons. Maybe they're inflammatory. Inflammatory meaning they're just they're just emotional flame ups. They're not they don't contribute. They're not contributing to the factual nature of the case. They're just purely there to kind of inflame people's emotions. So again, different reasons things can be excluded. That's one of them. Things can be excluded if they're irrelevant in the opinion of the hearing officer. Lots of different ways. The exhibits, they're the documents that are accepted into the official record. So those are called exhibits. We talked about ex parte communication. That's communication between the fair hearing officer and one of the parties when the other party is not present about the material aspects of the case. Ex parte communication is not allowed. It's called a fair hearing for a reason. Wouldn't be fair if you could get the hearing officer alone and talk with them about the merits of the case on an individual basis. Both parties have to be present for that, because then both parties have the opportunity to listen to that discussion and object if they need to. Similarly, the fair hearing officer cannot receive written ex parte communication. All correspondence and documents you send to the fair hearing officer must be copied to the other party at the same time. Again, to make sure that everybody's got all the information they need to make the right and the fair decisions in their case. If something is inadmissible, it's documents or testimony that does not meet the standards for inclusion into the hearing record. We talked a little bit about why that could be. It could be inflammatory, it could be relevant, whatever. If it's determined to be any of those things, it's determined to be inadmissible. A joinder is adding another agency or school that may be responsible for providing some services as a party to the appeal. Just think about it as sort of a tack on, right? So a joinder is typically done on an agency basis. It's typically an agency or a school that's sort of added in because they're a critical component of what could make that case move forward or make that case be successful. The moving or non-moving party, we've talked a little bit about. The moving party is the one who asks the hearing officer to take action. Oftentimes that is known as the petitioner. 9 times out of 10, that's the customer or consumer. The non-moving party is the person or agency that responds. Strangely enough, they're also called the respondent. And those terms apply both to the original request for hearing and any motion made during the hearing process. And again, those terms are pretty stable. The petitioner is going to be the one that brought the request for the hearing. In other words, they petitioned for the hearing, and the respondent is going to be the agency or the person that's responding to that petition. And you'll hear that petitioner-respondent language referenced throughout decisions and those sorts of things. We talked about oaths a little bit before. The speaker swears to tell the truth. Very serious consequences for the appeal and for the person if he or she is not honest about after agreeing to tell the truth. So important that you remember. And again, if there's a religious objection to oaths, oftentimes one is asked to affirm. They are legally considered the same thing. Objections. It's a statement you make when you want a fair hearing officer to ignore or exclude a document or a part of witness testimony. There must be a good legal reason for the objection. So a good enough objection isn't, you can't be, I disagree. You can refute a person's testimony, which means to present evidence that is counter to what that's been presented. But you have to have a legal reason for any sort of objection. The official record or the hearing record, they're the documents and the recorded testimony that the fair hearing officer will consider when making the decision. And again, the main focus of a hearing officer is to maintain a clear, clean, and concise hearing or official record. The opening statement, simple. It's just a brief summary of what you hope to prove that day. That's it. So your formal introduction of the issues and facts to the fair hearing officer. The party, a necessary participant in a hearing. Generally, the parties are the customer and the agency, or, as we've said, the petitioner and the respondent. Pro se means for oneself. A pro se party is one that represents him or herself at a hearing as opposed to being represented by an attorney. So someone who is representing themselves pro se is representing themselves without an attorney. A recess is just a pause or a break in the hearing. The record, the documents and recorded testimony that the fair hearing officer will consider in making the decision. Show cause. Tell me why. A show cause order asks the parties to state in writing why the case should stay active. If the parties don't respond or don't provide convincing reasons for the fair hearing officer to keep the case open, a hearing request may be dismissed. So show cause is generally something that is maybe the hearing officer hasn't heard from folks in a while, wants to see where the hearing stands, whether there's been an agreement, whether both parties are still interested in continuing. Oftentimes a show cause order will be issued. Statute of limitations. The law recognizes that there's not an infinite amount of time, money, and resources in the world to pursue claims. And in legal terms, to pursue a remedy means to be able to, bring a fair hearing or sue or whatever it is from a legal perspective, to seek remedy for something. And the law creates limitations as to how long you can do that based on what the particular issue is. So the statute of limitations is the law setting out the expiration date for claims. Pretty simple. Sua sponte means on one's own, a legal term used when a fair hearing officer decides to take formal action without the request of either party. And then the fair hearing officer has the capability to do that in certain circumstances. When they do that on their own, that means they're acting sua sponte. A subpoena is an offer commanding a person to appear at a certain date and time in a certain location in order to give testimony in a legal proceeding. Pretty straightforward. Subpoena duces tecum is an order requiring the specific document be turned over to a party for use at a legal proceeding. So a subpoena is asking a person to appear. Subpoena duces tecum is asking for a document. Simple. Testimony, the words of a witness who has taken an oath to tell the truth. Pretty simple. Venue is the location in which the hearing is taking place. And witness is the person who is responding to questions under oath at that hearing. So we hope that these slides were helpful to you as you prepare for your hearing. Please feel free to reach out to us directly through CSAVR if you've got future topics that may be of interest. We are the Independent Hearing Officer Work Group, and we're happy to develop these materials and hopefully to, in the service of making fair hearings a little bit more comfortable and a little bit more accessible for the parties involved. Have a great day, everybody. Thanks again for your attention.